Kouri Richins wants to do a podcast episode from jail. Why shouldn't she be allowed to do it?
Don't some judges just have the best voices? Just so deep and authoritative? This judge in the Kouri Richins case reminds me of Judge Gregory Warner in Letitia Stauch's case. That deep, resonant voice. I'd love to hear him on a podcast. Well, he'll probably appear on several. But that was the judge on Friday, June 2nd, wondering aloud about Kouri Richins' rights to speak with a documentarian. In our last video, we talked about Kouri yammering on with different documentarians, or at least one, directly through her prison calls or through a friend. So now we're going to talk about everything that happened in Friday's hearing. Well, before that hearing even came to be, Kouri Richins was fighting to wear street clothes, civilian clothes, not some type of prison orange jumpsuit. So she got her wish in part when it came to the clothes, but she did not get her wish when it came to not wearing restraints ever in court. And I found another odd request by Kouri's lawyer about even if she's found guilty, they still want Kouri to be able to wear civilian clothes during the penalty phase. I haven't often seen that language, but Kouri was flanked in court by two of her attorneys, including Sky Lazaro, and also present was Austin Nate. And Kouri's much talked about hair. People love commenting on her hair. It was brushed back into a neat ponytail from what I could see from the photo. Her signature deep left part still there. Many people have commented on Kouri's part. But Kouri wore a white button-down shirt instead of prisoner orange, by design of course. Maybe she wanted to appear innocent and wholesome. You know how defendants, when they come to court, like Jodi Arias, like Casey Anthony, they start dressing them up like school marms. You know, none of that sexy body contest that Casey Anthony, none of that gear. It didn't show up in court. By the time they get to court, they look like Little House on the Prairie, like buttoned up. But anyway, Kouri had on a white shirt. I'm sure she's sending a message of innocence. A white collar shirt a little bit, and you could tell it looked like black pants and cream colored heels with black soles. So she didn't shuffle in there with her, you know, flip-flops or prison flops or anything. And she didn't speak much at all, if at all. I didn't hear her speak once. Even when Judge Mrazek addressed her, you'll hear at the end him wishing her luck and everything and saying he would see her on June 12th, which is her next hearing date.
Ms. Richins, I wish you the very best. I'll see you on June 12th. Please take care.
So the judge spoke about the gag order, the proposed gag order in this case that the state wants to see or wanted to see. It was denied in part and approved in part. This is a complicated case because we have the criminal case where Kouri Richins is accused of getting rid of her husband, Eric Richins, using a poisonous drink. Then there's the case of the estate where Kouri and her sister-in-law, Katie Richins Benson, that's Eric's sister, they're, you know, fighting over control. Eric has his assets in a trust. He could foresee what was coming, so he started getting things ready. He could foresee the trouble coming. He was afraid Kouri was trying to harm him. He put his assets in a trust, being concerned for their three boys, their three sons. So that's that case. So it's criminal case, the civil trust case, and then there's the juvenile court case of what to do with the boys. Who's going to get the boys? And the lawyers are going to talk about that coming up too, and how the gag order could kind of have an effect upon all three cases. That's why there were so many people at this hearing on Friday. All different interests, all different lawyers, the guardian ad litem for the boys, and everyone pretty much got to weigh in. But first, let's talk about Kouri's clothes. Even if she's found guilty of the murder of her husband, Eric Richins, she wants to wear her own clothes. No prison clothes for Kouri, at least that's her wish. So this is what the motion said. Kouri Darden Richins, by and through the counsel of record, Sky Lazaro, that's her dark-haired, really smart, pretty attorney. It moves this court for an order permitting Ms. Richins to appear at all in-court proceedings, including all pretrial hearings, at which Ms. Richins appears in court in civilian clothes instead of prison uniform and without restraints by any means, including shackles or stun cuffs or belts. So that's what her attorney wanted. Her attorney was able to score her wearing, regular clothes. I'm surprised she didn't show up with the leather brown jacket she wore previously on her Good Things Utah interview and in one court appearance before she was arrested on March 8th. However, the judge didn't just say, okay, she doesn't ever have to wear shackles or anything. I think Kouri wore white again by design, just like that famous photo of her at KPCW when she had on that white coat. It's a long white coat and it makes her look like a doctor. That was my immediate thought every time I see that white coat on Kouri. And I'm sure many people's thoughts. When you see it, you just think doctor because it just looks like a doctor's white coat. But in addition, once the trial begins, Ms. Richins requests that measures be taken to ensure jurors never see her in restraints in or out of the courtroom. Should Ms. Richins be found guilty during the guilt phase of her trial, she respectfully requests that these measures be extended to the penalty phase of the trial. I've definitely seen it before where, of course, defendants don't want to show up in court wearing a prisoner's gear, wearing, the flip-flops and the socks and everything, shackled up, because visually, mentally, emotionally, we look at that just like I look at the white coat photo and automatically think doctor. My brain just thinks doctor before I even have to rationalize she's not a doctor, she was a realtor and a children's book author. As soon as you look at orange jumpsuits, you just think inmate, prisoner, guilt. So I see why, of course, lawyers don't want their clients going through court wearing that gear. But I don't think I've heard necessarily, almost in anticipation, should she be found guilty during the guilt phase of her trial, she respectfully requests that, she still wears civilian clothes and even no shackles, no restraints of any kind. At that point, if she is found guilty, I guess she's hoping that the judge will still see her as a civilian wearing civilian clothes and maybe go light on her sentence. Could be. But the court responded. Before the court is defendant's motion to allow defendant to appear without restraints and in civilian clothes throughout the trial. The state has not yet responded to the motion, and the state's deadline to do so has not yet passed. On a temporary basis until further order of the court, defendant's motion is granted in part and denied as follows. So I like this judge. He's very balanced. He listens to both sides, weighs everything. Number one, defendant may appear at in-court proceedings in civilian clothes instead of a prison uniform. So that's pretty allowable, and good attorneys always do that. Great attorneys always bring their clients clothes that they can wear, help them look decent when they come to court, help them not appear as a criminal. But number two, defendant shall be restrained as necessary to preserve the safety and security of defendant and the courtroom. The level and type of restraint shall be determined by personnel of the Summit County Sheriff's Office. So just like we saw Brian Koberger, interestingly, he's been wearing his prison oranges. I don't know if that was his choice. Most likely. He's been in there in shackles, so we can tell by the way he walks, his ankles are shackled. But with Kouri, I could not tell if she had any restraints on Friday or not. It's up to the Summit County Sheriff's Office to determine, does this person need to be restrained or not? In the Letitia Stout case, we know she needed to be restrained. She had previously tried to make a run for it when she was extradited from South Carolina out to Colorado. So yeah, when those were long court days, but when Letitia was escorted out during breaks, we could see her being, handcuffed. I don't know if they'll do the same with Kouri. It depends. I guess it all depends on an inmate, maybe their charges, if they've had a violent nature while in jail, how they've treated deputies, who knows? So that's why we saw Kouri in these clothes, and we'll see what she wears on June 12th. Will she wear white again? But first off, Judge Mrazek reminded everyone that Kouri is innocent until proven guilty while he was going through his debate over what to do with this gag order proposed by the prosecution.
With respect to preserving the integrity of the process, that is ensuring that Ms. Richins, who is presumed innocent, receives a fair and impartial trial, and a timely one. We have a First Amendment problem here. Do we have a genuine concerned of that court personnel or law enforcement are going to speak inappropriately?
But hypothetically, someone could approach, say, a secretary in the sheriff's office who has access to all of this information and offer a financial incentive to speak to them. I think that having this extra level of protection that is actually a violation of court order, that somebody could be brought before the court for for contempt, I think is the reason, the part of the reason why we're doing it.
I'm not sure I have the authority to enforce an order against people that are not counsel of record or parties in the cases. I can't hold another citizen in the county in contempt. Can I?
I think that would be difficult.
The press that's out there happened almost instantaneous. It was in response to the information that was filed by the state. We can't undo what's already out there. They can all they're going to do if a gag order is in place is continue to reprint the same press without ever giving Ms. Richins, a fair opportunity to rebut that, which I believe under the First Amendment she has. So, I think in essence, the filing of the motion of the gag order really does nothing but prohibits Kouri from, or anyone on her behalf, ever putting out anything that disputes what the state has already said. Would I support my client making a podcast? Absolutely not. But, in the essence of fairness, I don't think, given what's already out there, that one, there's any exigency because we're not going to undo it. Two, gagging anyone now is just going to create a disparity in fairness.
And that was a trip when he's wondering aloud, well, why should I stop her from doing a podcast from jail if she wanted to? The state, made up of prosecutor Patricia or Tricia Cassell, she wanted a big, quite broad gag order. We went over that gag order previously where they talked about people going crazy, camping outside of the prosecutor's office in Summit County, following court employees and meeting one of them at the gas station, pressing them for information, tracking down a private investigator involved in this case, the one most likely hired by Eric's sister, promising he would have a handsome actor play him in the movie version. Just so much stuff going on. So Prosecutor Cassell is talking about how crazy the press is going over this case. They're saying how some of the same witnesses potentially exist in the civil case and the estate case as well. That's why everyone was on a call or in person or wherever in this hearing. But Kouri's defense attorney is Sky Lazaro, and she's arguing that this gag order would prevent Kouri from combating the negative rhetoric or narrative that's out there about her anyway, based on what the state has published. She's concerned that the state is foisting this negative opinion of Kouri on the court of public opinion, and everyone is just already, if you read the press, most of us read these articles and we're like, yep, she's accused of poisoning her husband. She's accused of stealing all his money. And that's the thing. The estate case is informing the criminal case because it's assigning that motive of money and alleged theft and everything as to why Kouri allegedly got rid of Eric to begin with. A lot of people weighed in, but you can listen to the judge's final decision to grant the gag order in part and deny it in part. Basically, no attorneys of record or central parties in the case, including Kouri, need to be talking to the press.
I don't think your court staff should be followed around or hounded by press. Additionally, and I got to be honest, we've dealt with this a couple times now. The state's asking for a gag order because they're concerned about stuff getting out there, and simultaneously they're filing in public filings private information. And I know we dealt with that over the weekend, and then quite frankly, Your Honor, it happened again, and I raised the issue not with the court, but with counsel themselves, because there was an attachment to an exhibit to expert witness disclosure They contain my client's social security number and bank account number, which is, in my opinion, highly problematic. They have since remedied that. However, it was out there for at least a day.
Is there value in calming the public clamor about this case to protect these three kids?
I am all for the protection of the kids, and I am for the protection of the integrity of this process. I don't think it's going to calm it, is my concern. I don't think, I mean, they're just, every time something comes up, they're going to just reprint what's been printed. I think there's people that are going to continue to talk that the court has jurisdiction over, or does not have jurisdiction over, mainly from the Richins family, that, you know, there's already so much negative narrative out there with regard to my client that now stopping us from being able to even respond to it, you know, in light of maybe the rules of professional conduct, you know, I just think is unfair, because I just don't think that the press interest in this case is going to go away.
I don't want a fight to go public on where these kids should go.
We're only talking about a gag order with respect to conversations with the media. So,
Isn't that worse?
well, but that's where the problem is, right? That's where the problem with the integrity of the process. That's not. We want to continue the process with the other cases, and with this case, it's where the problem is with all of the craziness with the media, and the craziness with them trying to contact witnesses and contact parties, and that's where the integrity is going to break down, not with lawyers talking to each other, or lawyers talking with their other witnesses. And with respect to calming this down, I think this could solve the problem of calming it down, because if they're not out there digging up or trying to dig up witnesses or parties or law enforcement, then all they're going to have, and I understand Ms. Lazzaro's point that you know, maybe they want to respond, but the problem, but if what they have is what they have right now, they're not going to. It is going to calm it down. If they're out there trying to find a witness or find somebody who's going to give information, that's just going to harm the process. And you know, that is our reason for this, is to protect the integrity of the process.
Thank you, Ms. Cassell. That under the First Amendment of the United States Constitution, there is a constitutionally protected need for free and unfettered expression. That protection can be overcome if the state's interests are sufficiently compelling, and here, preserving the integrity of the process, and also protecting minor children from a public clamor that is potentially biased and or inaccurate regarding one of their parents, constitute compelling interests. But the mere existence of the compelling interests is not sufficient to overcome the presumption in favor of free and unfettered expression. Rather, the court has to look to and compare those compelling interests to other tools that are available to preserve the integrity of the process, ensure a fair and impartial trial, and protect the minor children. With respect to the minor children, the juvenile court is best equipped and has the legal authority to make whatever orders are necessary to protect those three kids from whatever comes out of these three cases. The court determines that the juvenile court is actively engaged in that process and should be trusted to effectively manage it. With respect to preserving the integrity of the process, that is ensuring that Ms. Richins, who is presumed innocent, receives a fair and impartial trial, and a timely one. there are other tools available, such as in-depth voir dire during lengthy jury selection, a potential change of venue if things get out of hand. Moreover, counsel of record and their teams and their expert witnesses and their investigators are bound by Rules 3.6 of the Rules of Professional Conduct and 3.8 as it applies to prosecutors to not make extrajudicial statements that are likely to prejudice the process. Given those other tools available to serve the compelling interest of ensuring the integrity of the process, the court rules that the state has not made a sufficient showing that a gag order serving as a prior restraint of speech by the parties, witnesses, or others would pass constitutional muster. For these reasons, the motion for gag order is granted in part and denied in part as follows. It is granted to the extent it seeks an order stating that lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide by Rule 3.6 of the Utah Rules of Professional Conduct. Moreover, it is granted to the extent that it requests an order that lawyers who have participated, who are now participating, and who will yet participate in the investigation or litigation of this criminal case shall not intentionally, knowingly, or recklessly permit any witness, investigator, consultant, staff member, or other member of their teams to make any extrajudicial statements which, if made by the lawyer, would violate Rule 3.6. And the court is ordering the lawyers participating in the investigation and litigation of this case to inform their witnesses, investigators, consultants, staff members, and other members of their teams about the terms of the court's order in this regard. The court rules that this order applies to all three cases. Having said that, the motion for gag order is denied in all other respects, without prejudice. If circumstances change in some unexpected way, the balance of the compelling interest expressed by the state versus the protections offered by the First Amendment may change. Ms. Richins, I wish you the very best. I'll see you on June 12th. Please take care.
So basically we need to get only official court updates, matters of public record. You know, reporters don't need to be chasing down court clerks at gas stations to press them for info. You know, they bandied about the First Amendment issues. They want to make sure it's a fair and impartial trial, but I like this judge because he's saying there's other ways. You don't have to issue some broad, sweeping gag order like in the Idaho case of Brian Kohberger to, you know, how much authority do you have and how much are you butting up against the First Amendment rights of everyone? You know, can you just gag every single law enforcement officer in the county and all civilians and everyone? No, there are ways, like the voir dire process can be very thorough. And Judge Mrazek is going to talk about if there's a change of venue that needs to happen, so be it. But Prosecutor Cassell is more worried about, okay, if the press and, you know, some publications do offer financial incentives. They offer money. So if someone knows a bit of info that's not necessarily in these public record documents, someone offers to pay them for that info. That's what Cassell is worried about. If that person were violating a court order, then they might have more incentive not to do it. But I tell you what, in these cases, state by state, it gets so confusing. I mean, I would play this whole court audio, but even that is confusing as to what is allowable, what is rebroadcastable, what isn't. I just take snippets here and there. It's very confusing. Almost like in the case of Letitia Stalk, when I believe they used a scapegoat, that woman who published the probable cause affidavit, but that was only because it showed up in the court record publicly and there was some kind of internal mistake where it's more of a matter of technicality. And I feel like they used that woman as a scapegoat for leaking Letitia Stauch's affidavit. State by state by state, it's like, okay, or even county by county. Yes, maybe this booking photo is allowed. No, it isn't public here. That's why we haven't seen Kouri Richins' booking photo yet. It's so wacky to me. I wish there was more consistency to the whole matter, but I understand. Sometimes you have to take things on a case-by-case basis. That's what the judge is doing here. It's a matter of interpretation of the law at times. That's why the judge is like, do I have the authority to enforce an order against people that are not counsel of records? I can't hold another citizen in the county in contempt, can I? Basically, Kouri's attorney is saying the press is out there, you know, it happened. This case, it's not going to cool it down. All they're going to do, Kouri's attorney is arguing, look, if you issue some broad sweeping gag order, all the press is going to do is take whatever the state has put out there anyway and keep reprinting that without giving Kouri the First Amendment right to rebut it. Not that Kouri's attorney wants her going on Good Morning America or talking to podcasters or documentarians. She's saying absolutely not. She does, I guess, want to reserve the right for Kouri to tell her side. And again, I think Kouri should be able to talk all she wants because she might be digging her own grave by doing so. Either she's getting the truth out there about her innocence, or if she will be found guilty and is trying to play innocent, that would harm her as well. And Kouri's attorney did mention how the state had made a big oopsie by publishing private information such as Kouri's social security number and her bank account number in public filings. But that was remedied. The judge seems really concerned wonderfully about the three young sons involved here. That's why the guardian ad litem was on the call, and the judge wants to know, if I issue this gag order, would it calm some of the public clamor and protect these three boys? Everyone wants to protect the three boys as well as the integrity of the case. But like Sky Lazaro said, I don't think it's going to calm it. They'll just be reprinting. And she even gave a slight towards Kouri's sister-in-law. Sky said, I think there are people that are going to continue to talk that the court does not have jurisdiction over, mainly from the Richins family. So that was kind of like Eric's family side is going to continue to dog out Kouri, mainly from the Richins family that have there's already so much negative narrative out there with regard to my client that now stopping us from even being able to respond to it in light of the rules of professional conduct is unfair. I just don't think that the press interest in this case is going to go away. I totally agree with Kouri's attorney there, although I don't agree with any slights, you know, be they subliminals or covertly or overtly or whatever against the Richins family. Obviously, the Richins family is in pain. They are hurt. And if they honestly believe and they're telling the truth about the fears Eric had of Kouri allegedly poisoning him for at least 3 times, allegedly stealing his money and everything, the Richins family should be able to say whatever they damn well please. So they can talk, and if they are the proper people to take care of those 3 boys and, you know, offer a continuity and help them heal and grieve and get over all this trauma inflicted upon them, oh my goodness, it's sad. While I'm still attempting to get Kouri's entire book, Are You With Me? I have seen more and more snippets. Doesn't the rendering of Eric Richins on the inside where he's sitting there on the bench with his little boy with angel wings on, it looks kind of, not to slight any artist or anything, but he's looking kind of like a brother, don't you think? I mean, I was like, I don't know. He's there sitting next to his boy with his arm over him, the little boy, you know, his fair skin, blue eyes, and Eric, his skin is looking, I mean, his beard looks more like him, but I don't know, the way it's rendered, I'm wondering, is that speaking to something else we're going to find out in this case? You know, the allegations of Kouri carrying on an affair allegedly throughout the whole marriage. We don't know if it's true. That's what's been alleged. I don't know. I'm wondering more about this, especially when I saw that rendering. It looks different than the one on the cover. The one on the cover, he looks fairer skinned. But anyway, on the inside, it also reads, Are you with me on Christmas when Santa delivers my presents? When I rip through them as fast as I can because I can't wait to see what's next. Did you see what I got from Santa? Everything in light of what Kouri's being accused of makes this book and the writings so much worse. If Kouri did take Eric off this earth, away from his 3 boys, imagine writing, "Oh, Daddy, did you see the Christmas presents?" It's like alluding to, "Did you see what Mommy got me? Well, you're not really here, but Mommy got me this stuff." It's just really sickening. But of course, Kouri, again, like the judge reminded us all, is innocent until proven guilty. We look forward to her next in-person hearing, 9 a.m. local time, Courtroom B, June 12th. 1 Chronicles 29:11, "Yours, Lord, is the greatness and the power and the glory and the majesty and the splendor, for everything in heaven and earth is yours. Yours, Lord, is the kingdom. You are exalted as head over all." I will let you guys know if I get the full WebEx video. It's so confusing. There's no, to me, like clarity about this, that, this. It's just, you just have to dig and dig and dig and try and find these court proceedings, which should be all a matter of public record. I know we are not entitled to everything, but when a man loses his life, dad to 3 little boys, and his wife is accused of poisoning him at least 3 times, stealing his money, of course the public is going to clamor to see him get justice. So we'll see what happens. Thanks so much for watching, and stay tuned.